Next case is Jonathan Thomas Linkosky versus the Commonwealth Department of Transportation. Representing PennDOT is Mr. Terrence M. Edwards. Representing Mr. Linkosky is Ms. Sarah E. Linkosky.
Good afternoon. In this matter, a driver obtained and then misplaced a driver's license camera card issued by PennDOT. Before requesting a duplicate camera card, the driver pled guilty to DUI in Ohio, and his driving privileges were suspended in that state. PennDOT refused to issue a duplicate card because at that point, the National Driver Register reflected the Ohio suspension. The issue is whether PennDOT's decision to consult the National Registry before issuing a duplicate card was proper. Mr. Edwards.
Good afternoon, Chief Justice Saylor and Justices of the Supreme Court of Pennsylvania. May it please the Court, I'm Terrence M. Edwards, Governor's Office of General Counsel, representing the Commonwealth of Pennsylvania Department of Transportation, Bureau of Driver Licensing. One of the primary goals of the Pennsylvania Department of Transportation is to improve traffic safety. Likewise, one of the primary goals of the National Highway Transportation Safety Administration, which is referred to as NHTSA, is to improve traffic safety. Neither of the courts below gave sufficient attention to the public safety implications of their decisions. Regardless of whether the employee of the Bureau of Driver Licensing who received Mr. Linkosky's application for a duplicate or replacement camera card should or should not have checked the National Driver Register, the fact is that employee did so. When the employee checked it, the NDR, the National Driver Register, showed that Mr. Linkosky's operating privilege was suspended on that date, December 4th, 2018, in the state of Ohio. And in accordance with Section 1503A1 of the Vehicle Code, the employee declined to issue the duplicate camera card. Our position, very simply, is in a situation like this where the result of the checking of the NDR showed that there was a legitimate reason for not issuing a duplicate or replacement camera card under the Vehicle Code, the employee had no choice but not to issue it, and we respectfully submit on the facts here, this court should reverse Commonwealth Court on that ground. The next point I'd make is Commonwealth Court holds that the department would not be allowed to check the National Driver Register for anyone who applies for a duplicate camera or duplicate driver's license if the person is, quote, a duly licensed driver in the Commonwealth at the time of the application and has paid the required replacement fee. Well, the Commonwealth Court assumed something that did not happen here. There is no evidence that the Bureau of Driver Licensing employee accepted the fee, the $5 fee. And that is, of course, because the employee checked the National Driver Register, saw that Mr. Linkosky's operating privilege was suspended in Ohio, and declined to issue it. So the first part of Commonwealth Court's basis, i.e. the payment of the fee, as a matter of fact, there's no evidence that that happened. More significantly is the question of whether or not a person who is applying for a duplicate camera card is in a situation where, in accordance with the federal regulations, it does not result in the grant or extension of driving privileges in a participating state. And that, of course, is 23 CFR section 1327.5B1. It is true that on December 4th, 2018, Mr. Linkosky's operating privilege was not suspended. However, that's not the end of the story. In light of sections 1501 and 1511 of the Vehicle Code, neither Mr. Linkosky nor anyone else can operate a motor vehicle in the Commonwealth of Pennsylvania without a valid driver's license.
Counsel, I'm sorry, this is Justice Bear. Can you hear me?
Yes, I can, Your Honor.
Okay. In PennDOT's interview as their counsel, is a camera card a driver's license?
So I think it's cited in footnote 1 of the department's brief.
And I'm sorry, you broke up a little bit. The answer is yes?
Yes, it is, Your Honor. In footnote 1 of the department's brief, we cite to the regulation which specifically states that a camera card is a driver's license.
So obviously, therefore, a duplicate camera card is a duplicate license.
Correct, Your Honor.
Hard to argue the logic of that. Is federal law supreme in this matter? Do you have an obligation to follow the United States Code or the Code of Federal Regulations interpreting it?
Yes, Your Honor, we do. There's both, well, there's two parts to the answer there. One is the Class C driver, such as Mr. Linkosky. The other is the commercial driver. Under the Motor Carrier Safety and Improvement Act of 1999 and the implementing regulations, implementing statutes, the department is required to check every time somebody applies for a driver licensing product. That's motivated to a great extent by the federal government's concern that commercial driver licenses not be issued to people who are not eligible, but it also applies to Class C drivers as well. So we are required. And in fact, I believe in the brief, we cite to the federal statute that requires the chief driver licensing official to check the National Driver Register problem driver pointer system, which I haven't used yet, but the problem driver pointer system is a computer system that's run in Washington, and it contains all the information that is required to be provided by a state where someone is suspended and made available to any other state that's checking for a person who's applying for a driver license.
All right, thank you very much.
You're welcome, Your Honor.
Counsel, could I just jump in? More to the point there, to follow up Justice Bear's question. More to the point, our own General Assembly adopted the statute memorializing that requirement, right?
Yes, Your Honor.
So let me ask this. In response to one of my colleagues' questions, you cited the reg. Is the fact that there's not a statute explicitly saying that of any moment here?
No, Your Honor. Again, the NDR requirement is a national requirement. All 50 states and the District of Columbia are bound by it. We've never, the Department of Transportation has never objected to it. We accept that we are required to comply with it, and we do comply with it in every instance.
No, I jumped. I'm sorry, I lost you there. I jumped over to the camera card. Like, I remember you cited the reg on the camera card.
Yes, Your Honor. It's in footnote 1 of the brief. A camera card is a driver's license for 60 days. Once it's validated, if you get stopped, heaven forbid, by a state trooper, and you hand the trooper that, it counts.
Yeah, I think we understand that. My question though was, is the fact that the predicate for that is the words of a regulation rather than the words of a statute of any moment? That's my question.
No, Your Honor. We're bound to in compliance with the federal regulation to check the National Driver Register problem driver pointer system whenever somebody applies for a driver licensing product that will extend or either create the opportunity to drive or extend the opportunity to drive, and we have that here.
And in furtherance, and again, I don't know whose brief. I read the briefs, I write a note to myself. I have a note in my notes that 49 USC 3034 parentheses small e end of parentheses, it would, because I did look, would be the statutory basis for 23 CFR 1327.51. Do you see a distinction between those two, or does the federal law support the code?
Well, it's the same thing with our regulations, Your Honor. A federal agency promulgates regulations to further explain the intent of Congress, the same thing that PennDOT does with regulations that we promulgate to make sure that what the General Assembly wants done gets done. And in this case, that applies in both instances. The federal regulations implement the statute you cited, and our own statutes and regulations follow with those federal requirements.
All right, thank you.
You're welcome, Your Honor.
Counsel, this is Justice Donahue. The statute to which Justice Baer just referred is much narrower than the regulation that you're relying on.
It is.
It's narrower. It refers to renewing such a license. We don't have a renewal of a license here. Does that make any difference to you?
Your Honor, we're following the regulation. And I also quoted in my brief from the Federal Register that in the process of developing this regulation, the National Highway Transportation Safety Administration, which is the agency that issued the regulation, and explained in the Federal Register that its intent is ultimately to have every driver licensing transaction in which a person applies for a product renewal or a brand new driver's license, that the state check with the National Driver Register Problem Driver Pointer System. To answer your question, the regulation itself is broader than the statute. I agree that it is, but again, it gets down to a question of does the agency, in this case NHTSA, have the authority to implement the statute? It does. How did it implement it? It implemented it with this regulation, and the Department of Transportation here is bound to comply with it.
Hey, Mr.
Even though the
Edwards,
regulation goes far beyond what the statute anticipates.
Your Honor, as far as we can tell, it is not. There's nothing contained within the regulation. It may go beyond the statute, but there's nothing that is in the regulation which is contrary to the statute. It's that agency's interpretation of its own statute, and as it's done in Pennsylvania, and our regulations, if they properly implement a statute, in some instances they may appear to go beyond the statute. Unless there's some legal objection to them, we're bound by them. And that's how we treat the federal regulation.
Yeah. Well, you may have I believe you have an objection to this in this case.
Yes, Your Honor. Well, that's why we're here, Your Honor.
Mr. Edwards, just speaking for myself, I think it's very questionable whether you had an obligation to check that registry before you issued a duplicate card, my view, but I still think that leaves the issue of whether, having done so, there was anything wrong with doing that, and it did then provide a basis for denying the issuance of the card.
Yes, Your Honor. Well, as I started, whether the employee should or shouldn't, and I will say the policy of the department is to check every time someone applies for a driver licensing product. It's a relatively
different whether there's an obligation.
Well, I'm just saying that's the policy, Your Honor. That's what the department does, which is why the employee checked the National Driver Register here.
Counsel, if I can, I'm sorry, Chief, go ahead.
No, I'm just asking if there's any other questions.
Yeah, I in follow up to the Chief's question, I'm looking at 75 PACS 1513, which is our legislature's pronouncement on how one gets a duplicate. And all it anticipates is the payment of a fee, period. So, hearkening back to the Chief's point, where does the ability to intervene in that process come from, given our legislature's statement as to what you have to do in order to get a duplicate, which is pay a fee, and it shall be issued?
Yes, Your Honor. As we pointed out in our brief, we respectfully submit that the term shall, as used in that particular statute, particularly in light of the fact that it appears to be in conflict with Section 1501A3, is not mandatory. It's directory. If I could just quote from the Seventh Circuit, in a case called McCready versus White, the Seventh Circuit said, "Shall is a notoriously slippery word that careful drafters avoid." Well, the General Assembly did not avoid the use of the word "shall" in Section 1513, but we respectfully submit again that it is only directory, it's not mandatory.
I have a quick question. What is the consequence if if the Commonwealth failed to send an inquiry to the NDR when somebody's seeking a duplicate license?
Well, there is a possibility that it could, if it became known to the to NHTSA, that there might be a reduction in funding to the department. And in fact, I would just point to, and I'm trying to find the section, 23 U.S.C. Section 402C, which is relating to highway safety programs use of funds, does have a provision for the federal government not providing as much funding to a state agency for failure to comply. Now, whether that would happen for a single violation, I have no idea, but there is, it's the carrot and the stick. And to a certain extent, getting back to Justice Bayer's earlier question, it's not perhaps the stick that's applicable here, but the carrot clearly is.
Well, and the other thing that's going to happen is if this driver drives drunk in Pennsylvania and badly injures or kills somebody, PennDOT will be a part of the lawsuit for the negligent issue of the license. Not that you won't prevail in that case, and this case may depend on it, but you may rest assured that the plaintiff's lawyer will join you.
I'm well aware of that, Your Honor.
Thank you, Mr. Edwards. Ms. Linkovsky.
Justices, may it please the court, Linkovsky on behalf of Aplt, John Thomas Linkovsky. As Attorney Edwards pointed out, there's really only one issue today, which is, did the department err in failing to provide the licensee duplicate camera card when he appeared on December 4th, 2018? And we answer that in the affirmative. It's our position that the department is mischaracterizing the licensee's application for a duplicate camera card as a second application for a license renewal.
Is a camera card a license or isn't it?
Camera card is a provisional license, Justice Wecht.
So if it is, how do you avoid 1503, which bars PennDOT from granting a license to anyone who's suspended in another state?
Justice, actually, the prescription for what the licensee and for what PennDOT is supposed to do in the situation is laid out in 75 PACS 1513. If a permit or driver's license issued under the provisions of this chapter is mutilated, lost, or stolen, which is the case, or becomes ineligible, then the licensee must appear at the driver's license center, provide sufficient proof to the department that the license is lost, mutilated, or stolen, and provide the $5 fee. In this case, the Commonwealth actually admits that, and admitted in the lower court transcript, that had the licensee appeared at a driver's license center on the day of the hearing, which was January 17th, 2019, with the original camera card that had been issued on October 4th, 2018, the department would have issued him a Pennsylvania license.
But he lost the camera card. I mean, it's a counterfactual. It's a different history.
Well, Justice, it just proves that the issuance of a duplicate card is not a grant or extension of licensing privileges, which is what would trigger the need for the department to check the NDR. The Commonwealth admits that if the licensee showed up after the January hearing with the original camera card, despite the fact that they already know that his license was suspended on October 16, 2018, they would have issued him a license without checking the NDR.
That doesn't make it correct. That makes a glitch in their system that maybe they have to look at. Justice Barrett, let me just following up. All of statutory interpretation is to effectuate the legislature's intent. Do you really want to argue here that our legislature intended to allow somebody who got a recent drunk driving conviction in Ohio to drive in Pennsylvania within days or weeks afterward because of the glitch you're arguing?
Justice Bear, I believe that had the legislature intended for the department to check the NDR when a duplicate license or camera card needed to be issued, that it would have set forth in 1513 in those provisions. It explicitly does not say that. Therefore, the department is limited to what they're prescribed to do.
No, go ahead. I'm sorry.
I have nothing further on that point, Justice.
In 1513, the legislature said that if the driver loses his card, etc., that he'll obtain a duplicate camera card. The word duplicate seems to me to be important. To the extent you lose your license, you get another license. To the extent you lose your camera card, you get a duplicate camera card. To the extent that the federal law says, and actually the federal law addresses it directly, that you should check. And PennDOT, as the Chief Justice said, has a policy of always checking it. I'm just not sure how that offends anything.
Justice Bear, I'd like to point to the language of 23 CFR 1327.5 in that the issuance of a license includes but is not limited to any original, renewal, temporary, or duplicate license, importantly, that results in a grant or extension of driving privileges in a participating state. It's the Applt's position here, Justice, that the licensee's driving privileges were extended on October 4th, 2018. So that is when the department was triggered and obligated to check the NDR, and that's when they did check the NDR. And had the licensee been under suspension at that time, the department would have been correct in not issuing him a renewed license. However, the application for a replacement camera card is not a grant or extension of licensing privileges as stated in the
Great,
code.
thank you very much.
Yeah, thank
But
you.
you concede, counsel, that you just conceded to me that a camera card is a license. So how can issuing a camera card or a duplicate camera card not be the extension of such a license?
The extension of a driving privilege would be, Justice Wecht, in the event of a license renewal, which is exactly what the licensee did on October 4th. It is not a duplicate camera charge. The department is trying to categorize the processes outlined in 1513 as a second application for renewal, which it clearly is not. It's in the event of a lost, stolen, or mutilated license or camera card, which is a different situation than simply applying for a license renewal.
Thank you. Not much more you can say. Somebody else has? Oh. You have a question, Justice Bear?
Pardon me, Justice Bear, I can't hear you. I think you're muted.
I'm sorry. I was curious about your relationship with the Aplt. I thought you did a nice job on his behalf.
Brother.
I appreciate it. The Aplt is my younger brother, Justice
Okay.
Bear.
Thank you.
He has an able advocate, and we appreciate your
Thank you.
advocacy.
Thank you, Justices.
Thanks to both of you. Take a 5-minute recess as usual, and then call the next case.
The next case is Commonwealth of Pennsylvania versus Eric Rogers. Representing Mr. Rogers is Mr. Carl L. Morgan. Representing the Commonwealth is Mr. Benjamin T. Jackal.
Good afternoon. Appellant was charged with rape and related offenses related to attacks on several women. He sought to admit evidence of prostitution convictions for some of the victims in order to support his defense that the encounters were consensual. The trial court denied his request, concluding that the evidence was irrelevant and more prejudicial than probative. Following his conviction, appellant appealed, asserting that the preclusion of the evidence abridged his constitutional rights to present a defense and confront witnesses. He challenged the weight of the evidence. The Superior Court affirmed, agreeing with the trial court's evidentiary ruling and deeming the weight of the evidence challenge waived. This court allowed review to assess those conclusions. Mr. Morgan.
Yes, good afternoon, Chief Justice, Madam Justices, and Justice. My name is Carl Morgan. I represent Eric Rogers, the appellant in this case. I just want to make one correction on your recitation, Chief Justice. The lower court did not make a determination of whether or not the probative value was outweighed by prejudice. It was a blanket reliance on Commonwealth versus Deere and Commonwealth versus Jones, and just said, no, this is dealing with prostitution and it's irrelevant as to consent. So there was no evaluation at all. It was just reliance on those cases. It is so that Mr. Rogers attempted to introduce prostitution convictions, one in terms of conviction in terms of AP, and two in terms of the complaining witness MH. The offer of proof to the judge handling the rape shield hearing was that in MH's case, they were arrests in the area where the incident occurred with Mr. Rogers. Those acts were 12/6/2012 and 2/8/2012, and the alleged incident with Mr. Rogers was 9/15/2011. Though it was characterized as being arrests, those arrests resulted in convictions also. So he tried to introduce 3 convictions for 2 complainants. Based upon Commonwealth versus Deere and Commonwealth versus Jones, that was disallowed, and also the court disallowed any questioning in terms of prostitution whatsoever. And the point that I want to raise here is that relying on the cases of Jones and Deere, those 2 cases relied on the third-party consensual cases to say that a party cannot rely on the fact that a complainant had sex with a third party to try to prove that they consented in the present case. The reliance of those third-party cases to prostitution cases, I say, is wrong.
Well, why is that, counsel? Why is the opportunity for the Commonwealth to prosecute and convict perpetrators of sexual assault different when the victim is somebody who has prostitution offense in the past? Why are those victims entitled to a less of a measure of due process or justice?
Well, I think there's a difference in that you're dealing with economics and a profit motive. And once money is injected into the equation, then the whole dynamics of human sexuality is off kilter and has to be reassessed with a different test.
Mr. Morgan, I'm sorry, it's Justice Todd. If we accept this line of argument, it seems to me you're making the wholesale claim that a prostitute cannot be raped.
No.
Is that what you're saying?
No, that was going to be my second point. First of all, as I'm saying, that the injection of the profit motive alters human dynamics of human sexuality. And when somebody's trying to make a buck, they're going to try any opportunity to make a buck. But in terms of whether or not, in this case, appellant is asking the introduction of the prostitutional conviction to prove that, well, the complainant consented to prostitutional sex in the past, and therefore they consented here in this case. That is not what appellant is asking. Case law says that the rape shield law has to yield when there's considerations of a right to a trial and a right to cross-examine, when it deals with motive and or credibility and bias. And that evidence has to come in as long as it's probative and its prejudicial value is not overweighs the probative value.
So why don't you specify for, this is Justice Baer, why don't you tell us now precisely why, under the facts of this case, the prostitution gets in? Is it for bias? Is it for motive? Is it for credibility? What's your argument?
It's not for bias or motive, conceded. It's for credibility. And it's probative.
And I'm sorry to interrupt you, counsel, but try to get to the nub of it, as the Chief Justice might say. Doesn't your exception swallow the rule? Because credibility is always relevant. Again, evidence 101. Credibility is always relevant in every case. So therefore, the rape shield law and the rule, everything goes out the book if we say cite credibility as an exception.
Well, Judge, when somebody asserts a defense of consent in a prostitutional case, it goes to corroborating that defense. Now, to answer your question, Justice Todd, it's up to the jury or the trier of fact to determine on that one occasion. Just because you have a prostitution conviction doesn't necessarily mean you engaged in prostitution on that occasion. It's for the jury to make that determination.
Well, if that's the case, counsel, then why wasn't it adequate that you had the opportunity to cross-examine the victims on whether this particular instance was in fact a consensual encounter arising from prostitution? Why did you need to bolster that with this alleged history? And even if you didn't have your rape shield problem, why wouldn't that be a 404 problem for you?
Well, number one, it wasn't the court presiding over the rape shield hearing said that there was no, you cannot question about prostitution. So we weren't allowed to question about prostitution. And going to credibility, Justice Baer, in the case of AP, she was asked, well, did the defendant offer you money? And she denied that. And so it goes to her credibility, her conviction. It could be used to impeach her. As far as, again, answering your question, Justice Baer, the other complaining witness in the MH case had this convoluted story that she was looking to go get housing, and she met up. Before she met up with appellant, she sat outside a store across from her house. She smoked marijuana. Then she met up with him, and instead of going the most direct route that would take her to her destination and getting housing, she went off in this other completely separate direction and ended up at an abandoned property. So again, it goes to her credibility.
Counsel, I think I'd probably accept that. And I think your real lament here is you told a story, and I'm sure were you trial counsel?
Yes. No, I wasn't trial counsel.
All right, well, trial counsel, I'm sure trial counsel did a fine job. What was she wearing? What did her makeup look like? Was she drunk? Was she high? How long did they spend together? Etc. On and on and on. As in any rape case, the cross-examination does. And the jury didn't buy it. I don't know that means that you get the extra stone that on top of all that, she's a prostitute.
Well, but the problem is, and I was going
it's just as Wex said to you, that's just not probative. I mean, I think your lament is that your trial counsel told a story and the jury didn't accept it.
The problem with that is that it's prejudice to the defendant for not having that evidence that is there to corroborate his version of what happened. And the prejudice is that the trier of fact could go the other way and say, well, where are you getting this? Where are you getting this, this theory of prostitution when there's no evidence of it? And there could be a backlash. They could say, well, I resent you trying to say that this complaining witness is a prostitute, and we're going to use that against you and convict you out of resentment. As one of the cases that you were considering, well, before I get to that, I want to answer Justice Weck's 404 question. I'm not trying to use, again, I repeat, I'm not trying to use that conviction of prostitution as propensity evidence of the complaining witness. I'm just saying it's probative that she may have been out there on the day in question plying her trade.
Counsel, this is Justice Doherty. So there were 5 victims. This trial included 5 victims, but the defense wanted to target 2 so that the jury could possibly believe that the one is a victim. Explain to me how that probativeness outweighs the prejudice, considering you left 3 other out there, 3 other victims.
Well, the third one was also the defense was consensual prostitution. The other 2 had nothing to do with prostitution. So the probative value is, as I say, I think you have to take on each case, the AP case and the MH case. And I'm trying to say, in answer to Justice Baer, that it goes to the credibility, why those women were out there at the time. What were they doing? Now, one of the cases that this court has asked to review, not only Deere, but it was also Jones. And in Jones, Judge Bender said that to suggest that a complainant's several convictions for prostitution do not tend to make appellant's version of the offense more credible and probable is fanciful naivete. He also goes on to say, the complainant's past behavior indicates that she has actively engaged in sexual activity for monetary compensation. It may not conclusively prove the point, but it certainly bolsters appellant's version of events, and as such is probative evidence. That's all appellant is asking for. Not trying to prove the ultimate fact and issue of prostitutional consent, but that it's probative and it may be considered. Also,
Counsel, this is Justice Donahue. Assume that you're correct, and that Judge Bender was correct in his statement that it's probative evidence. That's not the end of the discussion. At that juncture, the trial court has to weigh the probative value against the prejudice, and the prejudice here is articulated in a rule of evidence enacted by our legislature in the context of the Rape Shield Law, which establishes as a policy of this Commonwealth that a rape victim should not be put on trial. So did not the trial judge do precisely what he was required to do in this context, was accept that it may be probative evidence, but the prejudicial value of it far, far, far exceeds any probative value of that evidence. Why is that not a correct analysis?
Well, because I would answer that in terms of the Commonwealth, there is no prejudicial effect. That's not
the point. We have a statement by our legislature in a statute that precisely and unequivocally states the sound policy that a rape victim should not be put on trial. And that is the statement of policy in the Commonwealth. The trial court looked at that evidentiary standard developed by our legislature, and our Supreme Court of the United States has put an imprimatur on using that type of rule of evidence in this context and said the prejudicial value based upon the policy statement by our legislature far exceeds the probative value here. And although you say it wasn't being used as propensity evidence, that is the probative value that you're arguing at the end of the day. He did it before, she could be doing it here. I'm not saying that may not be probative, but the fact of the matter is the prejudice of that type of evidence far exceeds any probative value that it might have.
But that has to give way to the right to present a defense and the right to cross-examine. In the Palmore case, the Superior Court has ruled that the credibility is at issue and the attack was not against the complainant. It wasn't an attack on her virtue.
But that's because there was a motive that was offered as evidence in that case. You don't have this here. I mean, one of the classic cases is the prostitute who's caught in the act with an individual in the act of performing sex. She runs away from the scene and cries rape. Well, the fact of the matter is she had been arrested the night before for prostitution. The defendant's defense in that case, her motive for saying I'm being raped is that I won't be prosecuted again for prostitution. That's not what we have here. That precluding a defense in that case would clearly be depriving a defendant of a defense, but we don't have that kind of nuance here.
No, but
purely evidence of propensity being used to establish that if she did it once, she's doing it again.
Well, all I could repeat, Judge, is that that I'm not using it for propensity. I'm not using it to make the ultimate determination of whether she consented or not. I'm just using it as probative evidence that a jury could find that based upon the conviction that she was out there on the day in question plying her trade. Now, I was going to get into the fact that there's no prejudice to the Commonwealth in that they're going to argue, regardless of the introduction of the prostitutional conviction, that the jury doesn't have to believe that she was working on that day. The Commonwealth's also going to argue that even if you do believe she was working on that day, that doesn't mean that she wasn't sexually assaulted.
Can I ask you, are there any limits? Are there any limits on this? I mean, what if the prostitution conviction was 5 years old, 10 years old, decades old? What if there were only arrests but not convictions? I mean, how are you going to prove this stigmatic label? This is a prostitute, signaling to the jury she's not entitled to not be raped. I mean, how are you going to develop this in a way that is limited, or are there no limits at all?
No, of course there are limits, Justice Weck, and that's what the Rape Shield Statute is for. That it will go through the filtering of the Rape Shield Statute, whereas Commonwealth versus Deere and Commonwealth versus Jones is a per se bar to that screening process. It says, no, those prostitution is irrelevant. So you don't even go into the screening process. In the Rape Shield screening process, one of the things could be, well, this is a 10-year-old conviction. It's too stale. It doesn't come in. or it doesn't fit the factual pattern. If there's a family picnic and the complainant's at a family picnic with elders and children and so on, and a defendant comes in with a gun, grabs a complaining witness, sexually assaults her, gets away, and then the defendant, arrested a month later, claims that it's mistaken identity, then and finds out that the complainant had a prostitution conviction, that prostitution conviction doesn't come in because it's not relevant, it's not probative, and that would be filtered through the rape shield statute. In terms, again, Justice Donahue, I don't think there's prejudice to the Commonwealth, and by allowing the conviction to come in, I don't think there's prejudice to the complaining witness. Because
that's a distinction I think that has to be made in terms of your discussion of prejudice, because what our legislature has done is they have made sure that the victim is not going to be prejudiced. It's not a question of prejudice to the Commonwealth. The rape shield law is developed as it is to prevent prejudice and embarrassment to a rape victim, not to the Commonwealth.
Exactly. And I would suggest that the reasoning behind the Commonwealth versus Palmore case should apply to this case. Now, I know opposing counsel is going to say, even in the ruling in the Palmore case, they say that it should not apply to consensual cases, to consent, only in fabrication. But again, I'm saying that the prostitutional case is different from the third-party consent case. And then so the prescription of Palmore doesn't apply. Now, in Palmore, they allowed evidence of the co-ed of the sexual nature against the co-ed coming in, and ruled in Palmore that wasn't an attack on the complaining witness. That wasn't an attack on her virtue, on her character. So that's I want to use that rationale here. We're not attacking the complaining witness's character. We're just trying to use as corroborative evidence to buttress his defense.
Morgan, I think we've now come full circle. I mean, we're circling back to your arguments, and we certainly understand them and appreciate them. And if you had a word or two of summation, we would like then to turn to the Commonwealth.
I would just like to thank you, Chief Justice. I would just like to point out a distinguishing factor between the Deere case and this case. And I don't know how it plays with this court or where that goes, but I think it's important to note that in Deere, when Deere was arrested, he denied raping the victim and denied even having sexual intercourse with the victim. But then at trial, he came up with this prostitutional consent defense. Now, though the court in its reasoning didn't state any of this, I can't imagine they didn't have in the back of their mind that somehow this defense was orchestrated in order to smear the complaining witness. In this case, appellant, when he went to the police, he said that this was acts of consensual prostitution before he even had counsel. And he also testified to that at trial. So I would ask this court to overrule the Deere and Jones case and to find, if you don't overrule them, that Deere is distinguished from this case. And with that, I would rest.
Thank you very much, Mr. Morgan. Mr. Jackal.
Mr. Chief Justice, and may it please the court, Benjamin Jackal on behalf of the Commonwealth. For more than 40 years, Pennsylvania law has recognized that a victim's sexual history with someone other than the defendant is not relevant to prove consent with the defendant on trial for rape. Deere and Jones simply applied this rule in the context of prostitution evidence. Defendant has not identified any compelling reasons to overturn Deere and Jones. Instead, his argument proceeds from the false assertion that the cases categorically barred prostitution evidence. In fact, both Deere and Jones recognize that the Constitution sometimes requires the admission of evidence that would otherwise be barred by the Rape Shield statute. Evidence must be admitted if it is exculpatory or if it is relevant in cross-examination to establish a witness's bias or motive to lie. Neither of those exceptions is implicated here. Defendant may deny it, but in reality, he merely sought to establish that two of the victims had a propensity for engaging in consensual prostitution encounters in order to bolster his claim of consensual intercourse. This inference is not logical and has been nearly universally rejected. Because Deere and Jones are entirely consistent with the requirements of the Constitution, and because defendant does not have a constitutional right to introduce irrelevant evidence, the Commonwealth respectfully asks this court to affirm defendant's judgments of sentence.
Mr. Jackal, it's Justice Todd. I think you go a little bit too far with your argument, because to say it's not relevant, as I think Justice Donahue brought out earlier, is really an overstatement. I mean, it is relevant, it's probative, it's just prohibited because it's so prejudicial. Isn't that the more accurate way of saying it?
Well, in fact, the lower court did provide alternative bases for its evidentiary ruling. If you look at page 4 of the lower court's opinion, it's Judge Anders' opinion, he did determine that any relevance was outweighed by any prejudice. And the facts of the case here indicate that there were no indicia that the rapes here were consensual prostitution encounters. The victims, MH and AP, were both attacked in the early morning hours. MH was on her way to secure public housing, and AP was sitting on a park bench. The Commonwealth introduced documentation that both victims suffered physical injuries, corroborating their accounts of how defendant attacked them. Defendant choked both victims, and he punched and kicked AP. Both victims promptly reported the attacks to the police. When the police showed up, MH was not able to speak to male officers who arrived and could only speak to female officers. And then 4 years later at trial, she broke down and sobbed in the presence of the defendant. Given this record, to suggest, rather, these aren't circumstances that would suggest that the encounters were consensual prostitution encounters. And given this record, defendant can't make out his burden to prove that the trial court, the lower court, abused its discretion in finding the evidence irrelevant.
Could I follow up briefly on Justice Todd's question? I want to tease out your position. Why would it be relevant? Why any of these women would choose to have sex with anyone else, to the question of whether they chose to have sex with this person? I mean, just conceptually, why is that relevant?
Well, it's of course the Commonwealth's position that it's not relevant.
Well, that's what I'm going to ask you in response to Justice Todd. I'm not sure where you were on that issue. Sorry.
That determination isn't binding legislatively in Section 3104, and in this case, in this court's case law, including this court's decision in Maharana, where the court reasoned that evidence of third-party consent is simply not relevant to prove consent with the defendant.
Counsel, I'm a little bit confused about this because I mean, for reasons that we've discussed, there appears to be. The question is it relevant to the defendant's defense? Not is it relevant to the prosecution's case? And the defendant's argument is, of course, it's relevant. And I think in the broadest sense of the word, it is more likely to lend credence to his defense that this was an act of prostitution if she had engaged in acts of prostitution in the past. But that's not the end of the discussion. Assume that there's minimal relevance, because if it's not relevant, I don't know why we have this case. I mean, the question that we have before us in this case is the interplay between what is even marginally relevant testimony and the rape shield law, and how those two interact with one another. I mean, do you disagree that the fact of prior convictions of prostitution is irrelevant? Do you believe it's irrelevant to the defendant's defense?
I do believe it is irrelevant to the defendant's defense. And at a basic level, Deere and Jones simply stand for the proposition that prior prostitution conduct should not be treated any differently from any other third-party consensual conduct under 3104. And I think that conclusion is sound.
Justice Baer, just following on Justice Donahue, assume for a second that none of these five had any prior prostitution arrests, convictions, etc., and the defense wanted to posit the theory. Let's assume that there's only one defendant to make this hypo a little easier. Wanted to posit the theory that she approached him for prostitution. She offered him money he offered her money, and she said, "Sure, I'll do it." Again, with nothing in the past, nothing in the record. Is there anything that precludes that defense? And there would be a he said, she said for the jury?
Perhaps that defense would not be precluded. That's not, of course, the facts before this court here. But moreover, that just because the encounter began with a prostitution agreement, that, of course, doesn't get to the ultimate question of whether consent was ever terminated or what the terms of consent were. And that's really
I'm sorry, go ahead and finish your answer.
That's just the principal issue before a trial when the consent defense is raised.
Well, I agree with everything. I actually think I'm probably helping you. I don't think that the creative cross-examiner is precluded from positing prostitution in this instance as a defense. What he's prohibited from doing is putting in past conduct because, as Justice Weck said, it's just not relevant to this matter.
I would agree with that, Justice Baer.
All right, thank you.
Okay, anything else, Mr. Jackal? We certainly understand the argument. It's a discrete legal issue.
No, Your Honor. Thank you, Your Honor.
Well, thanks to both counsel. And with that, we'll conclude the argument session for today and adjourn court